Hello, and welcome to this presentation, Idaho's Tort and Medical Malpractice Reform Statutes. In this presentation, I would like to provide a very brief overview of several statutes that have been enacted in Idaho that change the way medical malpractice cases proceed in the state. We'll talk about two different types of reforms. First, some changes that apply specifically to medical malpractice cases, namely, the requirement that the plaintiff go through a pre-litigation hearing before proceeding with the lawsuit, and also a requirement that the plaintiff present direct expert testimony. Next, we'll look at caps on non-economic damages amounts that apply to all types of tort cases, from medical malpractice cases to car accidents or slip and fall cases. As mentioned in the Stewart v. Jorgensen case, a medical malpractice lawsuit must be filed in court within 2 years of when the alleged conduct occurred. After the lawsuit is filed, under Idaho Code Section 6-1001, before the case can proceed in court, the parties must first participate in an informal and non-binding hearing conducted under the jurisdiction of the Board of Medicine. The hearing is intended to be expeditious and informal, with the panel consisting of an attorney, a physician, and a layperson, all of whom are impartial to the case, and this applies only to cases alleging malpractice by a healthcare provider, not other types of negligence tort cases. And the sole issue determined by the pre-litigation panel is whether the community standard of care was breached, or in other words, did the defendant provide substandard care? The panel does not determine what damages may have resulted from the error, if any. Additionally, the decision reached by the panel is completely non-binding in the subsequent court proceedings, and the panel's decision is completely inadmissible in court. In other words, if the pre-litigation panel found that there was an error, the plaintiff could not present this information to the jury. Some states have created laws requiring something along the lines of a finding of potential merit by a pre-litigation panel before being able to proceed in court, or allowing the findings of the pre-litigation panel to be admitted in court. The top of page 208 of the textbook talks about some of these options, but that's not the case in Idaho. It's completely non-binding and inadmissible in court. Considering the non-binding nature of the pre-litigation panel's findings, it kind of begs the question, why is it required? Is it good public policy? The potential benefits include that it gives the plaintiff a chance to be heard early on. Civil cases take years and years to go to trial, and in some situations where the plaintiff is bringing a lawsuit, they may feel like they were treated very poorly. Having a hearing early on gives the plaintiff a chance to voice their side of what happened, and in some circumstances, that venting may be enough. And if there is merit to the case, it may help the parties be more willing to settle. The hearing also gives the parties a hint of what pursuing litigation will be like. And in this regard, it may help the attorneys and the clients to understand earlier on the type of case and hopefully reach an appropriate settlement. For example, there may be a case where the plaintiff thinks it is a slam dunk and that if they took it to a jury trial, they would be awarded $1 million. But if the pre-litigation panel determines that the standard of care was not breached, it may help the plaintiff have a more realistic understanding of the potential merits of the case, and then the plaintiff's attorney may be able to convince his or her client to agree to a more reasonable settlement earlier on. So the upshot is that pre-litigation hearings may be a helpful tool in encouraging fair settlements. On the other hand, others may view them as simply another hoop to jump through to bring a lawsuit. In addition to the requirement for a pre-litigation hearing, there are also specific statutory requirements regarding the type of evidence that the plaintiff must present in order to prove his or her case in cases alleging medical malpractice. Specifically, under Idaho Code Section 6-1012, in order to prevail in a medical malpractice case, the plaintiff must, as an essential part of his or her case in chief, affirmatively prove by direct expert testimony and by a preponderance of all the competent evidence that such defendant then and there negligently failed to meet the applicable standard of care practice of the community in which such care allegedly was or should have been provided. It's a mouthful. And there are a couple implications of this statute. First, in medical malpractice cases, it modifies the four common law elements of a negligence tort claim: duty, breach of duty, causation, and damages. Specifically, in order to prove a breach of duty, the plaintiff has to have a qualified expert testify that the defendant breached this duty of care. So let's say there was a very blatant error, like a surgeon amputating the wrong limb. Now, a typical layperson on a jury may be able to conclude just from the circumstances that this type of error was a breach of duty, without needing a physician testifying as an expert to tell them this. But under this statute in Idaho, the plaintiff would still be required to present expert testimony that amputating the wrong limb is a breach of the applicable standard of care. Second, Idaho Code 6-1012 implements a community standard of care. About 2/3 of the states now have a national standard of care in medical malpractice cases. We'll come back to that. But regarding this direct expert testimony requirement, the statute specifies that the expert must be familiar with the community standard of care. And in many cases, courts have held that the plaintiff's expert is not competent to testify because he or she is not familiar with the standard of care for the community where the alleged malpractice occurred. It is highly unlikely that a plaintiff will be able to find a practicing physician from that same community that will be willing to serve as a plaintiff's expert witness. Being an expert witness is something qualified experts in fields such as medicine or nursing can do voluntarily, and they get paid to do it. But for a local physician to serve as a plaintiff's expert witness, that would entail testifying that one of their colleagues in the community breached the standard of care, and people very rarely want to do that. So what plaintiffs' attorneys generally do is hire an expert from out of state who must then consult with Idaho physicians in that community to familiarize themselves with the local standard of care. And if this is not done properly, the expert's testimony will not be admissible and the plaintiff's case will be dismissed. So it creates an additional hurdle for the plaintiff's attorney to handle. Additionally, the expert must be qualified in the same area of practice as the defendant. So if the case is alleging malpractice against an oncologist, the expert would need to be an oncologist. And finally, the expert witness must actually hold the opinions to a medical certainty. Some potential advantages of this direct expert testimony requirement include that it helps avoid the situation where the jury may incorrectly assume malpractice occurred based on a bad outcome. There are always risks involved in any medical procedure, and just because things do not turn out perfectly does not necessarily mean the provider committed an error that falls below the standard of care. Also, the statute clearly sets out what types of experts are qualified to testify. But the potential downside is that plaintiffs may have difficulty and may incur more expense in finding an expert who is qualified to testify regarding the specific community standard of care. So let's talk about this community standard of care requirement. Like I mentioned before, many states have adopted a national standard of care. The reasoning there is that if all American medical schools teach essentially the same procedures, if specialists are certified by national boards, then why don't we hold healthcare providers to a national standard? Idaho, on the other hand, has taken a different approach. Specifically, Idaho Code 6-1012 states that in a healthcare malpractice case, providers of healthcare shall be judged in such cases in comparison with similarly trained and qualified providers of the same class in the same community, taking into account his or her training, experience, and fields of medical specialization, if any. So hypothetically, if there is a lawsuit against an orthopedic surgeon in Pocatello in 2012, then the applicable standard of care is the type of care that was provided by orthopedic surgeons in Pocatello in 2012. The statute also clarifies that the term community is defined as the geographical area ordinarily served by the licensed general hospital at or nearest to which such care was or allegedly should have been provided. And then it addresses the situation in rural areas or possibly with a subspecialist where the defendant may be the only provider of that type in town or in the community. Specifically, the statute provides that if the defendant is the only provider of that type in the community, evidence of such standard in similar Idaho communities at said time may be considered. So that's the community standard of care requirement in Idaho. But what are some of the arguments for and against a community standard rather than a national standard of care in medical malpractice cases? Let's first look at some of the arguments against a community standard. One point is that if providers are trained under the same curriculum nationwide, pass the same exams nationwide, and obtain national board certifications, shouldn't they be held to a national standard in medical malpractice cases? Additionally, as discussed above, Idaho's community standard of care creates an additional hurdle for plaintiffs and their attorneys when it comes to making sure their experts are qualified to testify. And in many instances, at least all of the cases I am aware of, the expert witness ends up testifying that the community standard of care is the same as the national standard of care. But some arguments in favor of the community standard is that it seeks to address the reality that levels of care vary based on locality. There is concern that if applying a national standard, providers in Soda Springs, Idaho, or other very small communities would be held to the same standard as providers at the Mayo Clinic, for instance, who have access to much more or to many more resources. Additionally, different communities have different population characteristics. Therefore, the prevalence of different diseases is going to vary among these different communities. So determining whether or not certain treatment is within the standard of care, such as ordering a particular type of test for a patient with a particular set of symptoms, this determination logically should also vary depending on the community. And finally, the concept of a community standard of care may be more important in a rural state like Idaho, with some very remote regions. Of course, I'm not advocating that one approach is better than the other, and I do not think the community standard of care statute will change in Idaho anytime soon. However, I want you to be aware that in other states you may see a national standard of care apply in medical malpractice cases. Okay, so now we'll look at Idaho's statutory cap on non-economic damages in tort cases. And bear in mind, this applies to all tort cases, car accidents, slip and fall cases, dog bites, not just medical malpractice cases. Before we talk about the cap, let's review what non-economic damages are. Specifically, non-economic damages are monies awarded for non-economic or non-monetary harm. This might include pain and suffering, emotional distress, loss of quality of life, and then especially in wrongful death cases, loss of companionship or loss of consortium of a family member. And as was illustrated in the other materials you reviewed, many tort reform proposals focus on capping non-economic damages. So in Idaho, Idaho Code 6-1603 places a cap on non-economic damages in most tort cases. The cap was set at $250,000 when it was enacted in 2003, and then increases each year based on inflation. So the cap was reset at approximately $313,000 for cases from 2012. And keep in mind, this cap impacts only non-economic damages. So let's say there is a famous violinist who goes in for a hand surgery, and the surgeon messes up and the patient permanently loses function in the hand, preventing the patient from continuing to work as a concert violinist. Let's say that if the surgeon had not committed this error, the violinist would have been able to earn $3 million over the course of the rest of her career as a concert violinist. The cap on non-economic damages would have no impact on the violinist's ability to recover this award, because lost wages or lost income earning capacity are economic damages. But monetary compensation the violinist might obtain for pain and suffering, or for the emotional distress of losing function in one hand, would probably be capped at approximately $313,000. Plaintiffs will generally try to recover both economic and non-economic damages. And note that I said the cap would probably apply to non-economic damages. And that is because if the defendant's conduct was not just negligent, but also either reckless or willful, or if it constituted a criminal felony, then the cap does not apply. So let's go back to the example of the hand surgery on the violinist. Let's say the surgeon not only messed up and committed malpractice, but did so while intoxicated. A jury would probably find that performing a surgery while intoxicated is not only negligent, but also reckless. So in that case, the cap on non-economic damages would not apply. So obviously, this overview only scratches the surface on the procedures followed in medical malpractice cases in Idaho. But hopefully this presentation has been helpful in introducing the tort and medical malpractice reform statutes that have been enacted in Idaho. Thank you for your attention.